when I'm talking about pornography, I'm obviously not talking about protecting like child pornography or stuff that isn't consensual. I'm talking about straight up consensual adult, like 18 years or older, and like no shady stuff behind it, and why the First Amendment should protect this. Now, pornography stems beyond way just like pleasure and masturbation. It can serve as a very good career path. For example, there's a website called OnlyFans that has skyrocketed during the pandemic, in which people 18 years or older who have to provide legal documentation for being that age, which can decrease the chance of minors being forced into this position. The man or woman of age can make content, nude or not, and make a lot of money off of this content. They can set their own subscriptions, whether it be $5, $10, $15, $20. They can make a very good living off of this. As a matter of fact, the top OnlyFans creators make around $5 million a year, and OnlyFans only takes a 20% cut off of that salary. Also, talking about the porn industry itself, like actual actors, the top actors can get paid $300,000 or more a year for doing work. And so taking away pornography could serve as a really bad thing for people who are trying to make a career out of it. And it can take away a lot of jobs as well. Now, as for pleasure and masturbation, obviously porn addiction is a problem, but the action of masturbating itself, even doing it once a day, has no cons at all. As a matter of fact, it reduces stress, makes it easier to go to sleep, and it provides more neurotransmitters and more dopamine, the feel good effect in your body. And so if you take away pornography, it could possibly end up correlating to more alcohol addiction or nicotine addiction, because you took away millions of people's pleasure just to protect them under the First Amendment, when what they were most likely viewing was consensual and no shady stuff behind it. So these are all my reasons as to why pornography should be protected within the First Amendment.
In a 1973 case, Miller versus California, the U.S. Supreme Court ruled that obscene material isn't protected by the First Amendment. The ruling established the current legal guidelines for obscenity, much of which pornography, especially hardcore pornography, fits. The guidelines are as follows. A reasonable person would find that the work as a whole appeals to having or encouraging excessive interest in sexual matters. The work depicts or describes sexual conduct in a clearly offensive way, specifically defined by the applicable state law, and the work as a whole lacks serious literary, artistic, political, or scientific value. The actions required to produce pornography, performing a sex act with another person in return for a fee, meet the legal definition of prostitution. With the exception of some Nevada counties, prostitution is illegal in the United States. The only difference between prostitution and pornography is the presence of the camera. According to the World Health Organization, sex work is the provision of sex for money or goods. Of the nearly 800,000 people trafficked for sex work, 80% are women, and 50% of those women are minors. As pornography falls under prostitution, an illegal and exploitative industry, it should not be protected under the First Amendment. How can you prove that people on OnlyFans and that people who are these virtual sex workers, that this is a beneficial industry for them and that it should override the 90% of sex workers who want out of the industry?
So I think OnlyFans is an exception, once again, just because they set their own pace, they set their own payment, all that stuff. And another point to that is actually if, people who are trafficked, if they eventually get out of it, they could possibly have a chance to turn to OnlyFans themselves and turn their own career around, be their own boss, live their own life, all that stuff, and still make a good living. And if you take pornography away, you also run the chance of not giving a trafficked person possibly another job, while simultaneously taking away a lot of other people's jobs. People who aren't trafficked for pornography, is it fair to take that away from them just because the majority of them are trafficked?
Studies have shown that there's a high correlation between pornography and prostitution. Pimps are known to show pornography to prostitutes that they have trafficked or prostitutes that are underneath them in order to desensitize them to the industry and to give them an idea of what they should expect. They're known to show them hardcore pornography to desensitize them and to basically traumatize them into submission. Johns, so people who access sex workers are known to also watch pornography in order right before they go to the prostitute in order to act out that pornography onto the prostitute. So taking away pornography isn't necessarily going to eliminate the sex work industry, but if we took away every non-consensual or sex trafficked person in the sex work industry, we would not have the sex work industry as we know it today, as the vast majority have been trafficked in, and the vast majority do not want to be there.
So once again, I just want to reiterate why I think the First Amendment should be protecting pornography. Once again, it serves as a very viable career path. You can make upwards to $5 million, and that's obviously very good money. Once again, the point to masturbation, if you take away pornography, you are taking away millions of people's pleasure, which is something that, unless it's addicting, it causes absolutely no harm, and that person could possibly turn to a bad addiction or a bad habit such as alcohol or nicotine, you never know. And as for the court case's definition of obscenity, I find that to not be a very good definition, as it's basically a subjective definition. I mean, who is the court to define what people should see as like literary art or something like that, or something that's relevant to them? You can't be objective with art, is basically what I'm trying to say. So yeah, this is why I think the First Amendment should be protecting pornography.
It may be true that OnlyFans seems less violent and more consensual compared to other forms of pornography, but it is pornography no less. The First Amendment does not guarantee U.S. citizens a career in whatever is most profitable for them, regardless of legality. It restricts the federal government's ability to regulate the natural rights of U.S. citizens. It does not consider obscenity a natural right, and as pornography fits the current guidelines for obscenity and prostitution, it should not be protected by the First Amendment. As stated in the Miller versus California verdict, the courts do have the ability to prove what is scientifically or artistically valuable. As stated previously, over 90% of sex workers want out of the industry, and approximately 95% of sex workers have experienced sexual violence that would be criminal in any other industry. The whole of the sex work industry, which is proven to be highly dangerous and mostly illegal, should not be defined by its possible exceptions. And that is why pornography should not be protected by the First